So I'm just looking at this Claim of Right Act Scotland because I've actually got the full text for the Tumultuous Petitioning Act now. And it does actually refer to local areas, justices and so forth, but only from where the matter arises. So if you're actually petitioning about something that is a national matter or another place, then it has to pertain to that place, which makes me wonder about the Stonehenge petition, really. Should be going... But the thing is, they've abolished justices having to look at petitions or a grand jury. So in relation to any cases or causes to do with petitioning the government, it's not actually a matter for the local courts anymore. But there's quite a few things that are interested in the Scotland Act now, and the language actually has just helped me. The language and the use of words in this has really kind of helped me with the Bill of Rights, with the illegal prosecutions. Illegal prosecutions. By prosecutions of the Court of the King's Bench for matters and causes cognisable only in Parliament, and by diverse and other arbitrary and legal causes. So what I've done is I've put this on a separate line now, because that word there, this byword here, so that byword is like the byword while we start. So this is now separated into two parts. So that is read starting again like the first bit. So by prosecutions of the Court of the King's Bench. So this is illegal so how we read this is, we read it, that's the title, illegal prosecutions, and it is therefore, I would suggest that if we were typing this up, it would be kind of like this. Like, I'd put it like this. I think that this helps a lot with this. So if we make that little change there, okay, there. If we do that, so there you see there's a little 1 and a 2 there, right? That's how they do it in modern legislation. So we've got that 1 and 2. By illegal prosecutions. 1. By prosecutions is in the Court of the King's Bench for matters and causes cognisable only in Parliament, and by diverse, that is very different and wide-ranging other arbitrary and illegal causes, like what is routes and methods. So different ways, that different ways of prosecuting or punishing people or getting people. So other ways that may be besides the Court of the King's Bench. So basically, anyway, basically, it's saying anyway, but by other any other ways you can think of, basically, because illegal prosecutions in the Court of the King's Bench for matters and causes that are decided only in Parliament. Well, if you petition in Parliament over something, either of the Houses or the King, and it can't be decided in it's not a court to one of the, it's not a case to the courts. The courts don't decide matters. Basically, matters that aren't a criminal case or a civil case in local courts. Basically, that's what it means. If originally the case that you're bringing, and this word causes here, we find that word causes in the Scotland Act as well, so it does mean cases. And the fact is, like in a criminal case, the case starts with a witness in an investigation. So, it's the whole of the case and all of the facts and circumstances of the case. So I thought that was quite an interesting thing to note. But coming back to this, there's actually some really, really useful and important things in this. So this is the forcing of ledgers to depone against themselves in capital crimes, however the punishment be restricted, is contrary to law. This is actually quite a major breakthrough, actually. So leges is knowledge. It means information's knowledge. So that the forcing of people to dispose themselves with their own knowledge, forcing them to basically, get themselves convicted in capital crimes, however the punishment may be restricted, is contrary to law. So that's almost like when you get arrested, you've got the right to remain silent, but anything you do say can or will be used against you in a court of law, but they can't force you to speak. The police aren't forcing you to speak, right? You have the right to remain silent, right? But what it's actually saying is that the forcing of people with informations in a crime, however the punishment that they're going to give you is going to be restricted, is against the law. So this is absolutely critical now. What this actually means is that if there is any information, right, forced information, basically, even if it forces you to admit a crime against yourself using force and information, forcing you to, dispose yourself, forcing you into it, however much your punishment is restricted, is against the law. So I think this is relevant to fines. Like when you get a speeding ticket through. So you've got the right to remain silent, but what they're doing is they're using evidence, right? Like photographs, pictures, speed camera footage, right? And what they're doing is